versus Nieves.
Thank you. Ms. Chang?
Good morning. May it please the Court, my name is Lillian Chang. I'm an Assistant District Attorney from Middlesex, and with me today is Assistant District Attorney Kate McDougall, who is the trial prosecutor on the case. The central issue on appeal, and really the only issue that this Court need decide, is whether a petition for commitment under 123A may proceed against an incompetent respondent. And the answer to that is yes. Unlike previous versions of 123A, the current statute makes no distinction between respondents based on competency alone. In Section 1 defines who are sexually dangerous persons. The primary definition are persons who have been previously convicted of sexual offenses, who suffer from a mental abnormality or personality disorder that makes them likely to engage in sexual offenses if not confined to a secure facility. Section 1 also includes what we might call a subset of persons who have not been convicted, who have not been previously convicted of sexual offenses by reason of their incompetency to stand trial. And that's provided for by Section 15 of 123A. So by the very structure of the current statute, the statute contemplates that all respondents, whether they're competent or incompetent, will proceed under the proceedings provided for under 123A.
Let me ask you a fundamental question.
Yes.
Can an incompetent person assist their counsel in representing them in a 123A petition?
Well, I think that will vary from case to case. As this Court has recognized, a person who is incompetent may be competent to make certain decisions and not others. However, the very nature of civil commitment, as this Court has recognized, both under 123 and under 123A, is that there are certain individuals who, because of mental disease or defect, are unable to control their behavior and unable to live in society with other people. And the fact that, and that is the very nature of these civil commitment proceedings. 123A itself provides a multitude of procedural safeguards for respondents, as this Court has noted in various cases, including the right to trial by jury, including the right to counsel.
Would it be appropriate, if assuming we agree with you on at least to me appears to be clear, that you can try an incompetent in one of these proceedings, and in addition to what you're now ticking off as all the due process procedural safeguards, should we direct that a guardian ad litem be appointed for this gentleman to act in his case? Pardon me?
In this particular case or in cases generally?
Well, maybe both, but at least in this particular case, to act in his stead as kind of someone who can consult with counsel?
Well, I think that is going to be a decision that will be best left to the trial judge, who has the best access, who can observe the respondent, who has the best access to the facts of that case.
Well, as I understand the situation, this gentleman's never going to improve. His disability is uncorrectable, if that's the right word, mental retardation. It's not something that medication or anything else is going to alleviate. Am I right?
Well, I do disagree with that, Your Honor.
Okay.
Dr. Joss, in his initial competency evaluation in September of 2000 and 2002, I believe, noted that Mr. Nieves' condition seemed to be fluctuating, or his competency would fluctuate, or has fluctuated throughout the years, and that when he is on medication, he does seem to improve to some extent.
Okay, so that would sort of militate in favor of what you're talking about. Let the trial judge, if it goes forward, decide when it comes up whether he's at a stage where he can actively help or not.
Yes. And, Your Honor, I think it's important to note that this decision about guardian ad litems, I think it is a complex issue, and it does raise a number of issues, including how a guardian would interact with the attorney, how the guardian would interact with the court. And those issues may invoke interests other than those of the district attorney and those of the attorney for the respondent.
I don't understand what you mean by that.
That's the whole point.
I can understand why there may be interests different from the district attorney, but why would there be interests that are different from the respondent's attorney?
With respect to a guardian ad litem?
Yes.
Clients can disagree with their attorneys, that's why.
Right, exactly.
Yeah. Could I ask you, with regard to the guardian ad litem, your brief takes the position that the right to a jury trial cannot be waived. And it seems to me, I don't quite understand why. If we've gone to the effort of appointing a guardian ad litem and applying the substituted judgment standard, I don't see why the guardian ad litem would not have the power to instruct the respondent's attorney to go ahead and waive a right to jury trial. If we're going to appoint a GAL, at least allow trial judges to appoint a GAL, instruct the GAL to use a substituted judgment standard, why can't that be used to waive the right to a jury trial? I don't follow your argument on that piece of it.
Well, Your Honor, in preparing for this argument, I think as I thought through the issues, I think I have tended to come closer to your viewpoint, that if we are going to have a guardian appointed for a respondent, they are essentially stepping into the shoes of the respondent, and they should be able to make decisions that a respondent should be able to make.
That's the whole point.
But that's why I asked you the question. Yes, of course, the guardian might differ with the attorney, but that's not, if you're doing a substituted judgment, you don't typically say the defendant has interests that are different from his attorney. If there's a conflict between the defendant and the attorney, that has to be resolved by the judge. Sometimes the attorney says, I can't continue to represent. I mean, you're in a substituted judgment. I mean, you're essentially standing in the shoes of the respondent.
That's correct.
But I thought you were saying that you know, the guardian ad litem raises all kinds of problems. I mean, the guardian, I mean, you proceed as if the guardian ad litem is standing in the shoes of the respondent.
That's right. And the reason I say that is because
it may be, for example, to take Justice Osmond's hypothetical, that the guardian ad litem wants to waive the jury trial. The attorney doesn't want to waive the jury trial. The attorney thinks it's a strategic or other reasonable consideration that this case is a good case for the jury.
Or the respondent wants to take the stand, the attorney,
whatever
recommends against it,
Then you get into, we've got a whole body of law which explains what happens when there's an irreconcilable conflict between an attorney and a respondent. It's complicated. It's a very difficult area, but I think courts have developed enormous expertise over decades of how you deal with people where the attorney reasonably and passionately feels that the course of conduct that his or her client is embarked upon is injurious to the client. If you have a guardian ad litem, you're essentially in the same consideration.
Well, I agree with Your Honor with that respect. And the reason I brought up the issue that it may be more complex than the traditional role of a guardian is that if you look at the role of guardian ad litems in cases where they use substituted judgment, which is normally in the administration of medical treatment, normally the guardian ad litem ascertains the person's preferences, makes a report to the judge. The judge then makes a ruling as to what he or she believes that person would do in that particular situation.
But did you just say the first part? Normally the guardian ad litem ascertains the preferences?
Right, ascertains what the individual would do.
Yeah.
Well, frequently the person is incommunicado, can't and may not have. I mean, sometimes you try to reasonably encounter it, but I mean, what's the alternative here? I mean, what are you proposing as the alternative?
Well, I think that the guardian ad litem is a protection that the court should have the discretion to make, depending on a case-by-case situation.
If the judge has, to go back to Justice Lyons, if the judge has determined that the respondent is incompetent, doesn't that necessarily include, in fact, first and foremost includes that is incompetent to deal with his or her attorney? So, and that's critical because all of the due process protections that are built in presume, an adversary system.
Correct.
So if you have a respondent who cannot communicate, I mean, that's the whole basis of incompetency. He may be competent to do other things. He may be competent to eat. He may be competent to exercise, but he's not competent to stand for trial. And central to that is that he's not able to communicate with his lawyer. So essentially, where does that leave the lawyer? You're saying it's discretionary, but in every case, because we're only here if the judge has made a determination that the respondent is incompetent, correct?
That's
for
right.
purposes of trial. So by definition, every single person who's been declared incompetent cannot communicate with their attorney.
Well, I
for
think
purposes of proceeding with the trial.
Proceeding with the trial. I think that you can also take guidance from how proceedings are run under 123, in which persons there are commonly, they're routinely incompetent to proceed. And to the best of my knowledge, guardians are not appointed for them.
Yeah, under Chapter 123,
Yes.
If a person is incompetent, they are committed for a period of 6 months initially and then every year after that. But doesn't the government have to initiate that proceeding, the recommitment proceeding under Chapter 123?
They do.
But under Chapter 123A, isn't it the person who's been incarcerated? They're the ones that have to initiate the proceedings.
That is correct.
So if a person were incompetent and didn't understand they would have a right to petition to get out under Chapter 123A, shouldn't we be appointing a guardian ad litem for them basically to serve in a lifetime capacity?
Well, that is one option. 123A, however, also provides that the respondent, the spouse, issue, next of kin, or friend may file a petition to review a person's commitment under Section 9. So it's not just the respondent.
Yeah, but they may have
him or
conflicting
herself.
interests.
True. So in that case, a guardian ad litem may be appropriate. Yes.
You may want to back off a little bit on this guardian ad litem. What standard would the guardian ad litem use to make decisions like waiving jury trial, deciding whether the respondent should testify and all that? Substituted judgment? We've never used that beyond the medical context or the estate administration context, and it creates a whole bag of worms on how you figure out in this context whether a incompetent respondent would in fact want to waive a jury trial. So maybe a guardian is superfluous. Maybe just leave these decisions to the lawyer acting under well-established standards about zealously representing his client.
Well, that is the alternative to appointing a guardian, is to leave the adversarial nature of the process.
Yeah, suppose they get into a big disagreement. Who trumps who, the lawyer or the guardian? Do they all go off to court again, and it all comes up here to decide who prevails? This could open up a real tangle.
I mean, I think that those are the complexities of this issue that this court would have to address.
How many people out there are in these circumstances, do we know?
There has been, to my knowledge, no formal count. I did an informal survey of our counties. There's 2 in Suffolk. There's a Commonwealth versus Burgess, which is a respondent under Section 15 who has gone through the first stage of Section 15 and is under appeal. There's probably under half a dozen cases.
Well, you're here to help us out, so...
I thought the February 8th, the filing, I think, of the Commission of the Department of Correction, I think gives the most up-to-date of the number of cases. That all of this is taking place in Suffolk and Middlesex, right?
Well, there are actually cases in other counties.
Well, you're here to help us out with the complexity. What's your answer to should there be a guardian or not?
I think that is a decision that should be left to the discretion of the trial court. There may be instances in which a guardian is appropriate, and there may be cases in which it's not.
What guidance do we give if it's left to the discretion of the trial judge, what guidance do we give the trial judge?
I think it's no more guidance than a trial court normally has in these situations. They deal with these cases all the time. When they see a person is incompetent, then they address that issue.
What are they looking at? What are they looking at? I mean, because this trial judge has already made a determination that this person is incompetent to stand trial, correct?
For the time being. Well, they look at whether a person can meaningfully assist with their attorney, whether they have a meaningful understanding of the proceedings that are against them. What is the nature of their competency? Will they recover? Or is there a possibility that they will recover?
So we do what trial judges used to say, including me, when one of these decisions came down. The SJC or appeals court told me to think about a guardian ad litem. Yes. And then what? Good luck. Is that what you do?
I think that is...
And by the way,
yes.
It's all going to be appealed, and we're going to tell you did it wrong. And we're going to have to...
That's the good luck part.
And then we're going to have to come up with some kind of guidance as to why this was wrong. So...
Well, I think the trial court is in the best position to make those kinds of judgments.
I'm not sure the trial court would agree with you.
Could I ask you to clarify one thing?
Sure.
Just as a point of procedure, to your knowledge, under Chapter 123 proceedings,
Yes.
are guardians ad litem never appointed or sometimes appointed?
I can't say that they are never per se appointed, but they are rarely, if ever, appointed. When I spoke with the department officials, they said it just doesn't happen.
It just doesn't happen.
They depend on the attorney to represent.
The best interest. We rely on the attorney's obligation to represent the client's best interest.
Exactly.
Thank you, Ms. Chang.
Thank you.
Mr. Gillis?
Thank you, The phrase irreconcilable mess comes to mind. This is a horrendous situation. There is absolutely no easy solution, and I don't think you'll find any in the Commonwealth's brief or my own for that matter.
Well, surely you admit that the statute is reasonably clear in its intent. It intends that incompetent, sexually dangerous persons be subject to 123A.
Absolutely, and I think there's
And you make that very clear, and you answer the first question, and it's not an issue.
That takes care of the first question. Now,
Yeah.
So now the second question is, does this violate due process? The answer is, does it violate substantive due process? No, because it doesn't shock the conscience, particularly with all the procedural safeguards in the statute. So now you get down to the rest of the questions. What should you do in addition to those safeguards to ensure procedural due process? The only thing I can see is, should there be a guardian ad litem?
Well, respectfully, Your Honor, I do disagree. I think Justice Cordy's decision, or the decision of this bench as outlined in Justice Cordy's decision in Commonwealth v. Torres, should decide whether or not a incompetent individual can be committed under 123 consistent with due process.
What are you going to do if the answer to that, if we agree with you that the answer to question 2 is no, okay, are you recommending release?
No, Your Honor.
So you are recommending,
Shipping them over to...
well, I mean, just indefinite confinement, because there are cases where, as Justice Glaney alluded to, this is not a temporary problem.
Correct.
Right? I mean, that seems to me maybe that's the solution, but that seems to me to raise all kinds of due process concerns.
I believe what I suggested in my brief, Your Honor, and what I firmly believe, and unfortunately, since my client is of not terribly much help to me, it really does come down to my views for this Court, and I try to be clear on that.
Yes, I appreciate that, yeah.
I believe that the only reasonable solution is what I would deem the term diversion to Chapter 123.
But is a mentally retarded person committable under Chapter 123?
Yes. And Mr. Nieves is more than just mentally retarded. He is schizophrenic. He is mentally retarded. He is addicted to polysubstances, and he has a deeply ingrained antisocial personality disorder.
So he's different from some other people.
So the diversion to 123 would achieve what?
Well, and I was actually going to start out with the point that both in 1996 and respectively in 2006, and at numerous points before then and between then, Mr. Nieves was committable under Chapter 123. Matter of fact, I consider it malpractice on the part of the Department of Mental Health in 1996 when they sent him home with his parents. There was a report on file that Mr. Nieves needed an intensive, structured setting to not be a risk to society. And even though there was that report, he was sent home.
But could I back that? Excuse me, though, before we, in order to go along with your view that notwithstanding the legislature's intent that these people be tried and processed under Chapter 123A, that we have to, in your words, divert them to 123, there has to be a constitutional infirmity, a constitutional dimension to what the legislature has said. What's the constitutional flaw?
The risk of erroneous deprivation of liberty. In other words, and that's why I.
But you have that under Chapter 123.
Right, but you have, but the analysis in Matthews and as outlined in Torres, the third prong is, well, is there some substitute mechanism, some procedural protection that can minimize the infirmities of the system that we are struggling with? And in this case, you have Chapter 123, and keep in mind.
What is the infirmity?
The infirmity is that an individual who can't defend themselves, and I'd like to answer it, if I may, this way. Chapter 123 and Chapter 123A both apply to individuals who are mentally disordered by definition. There are great differences between 123 and 123A that make 123A, in this Court's previous decisions, broader in its reach than 123. Broader in the definition of illness, broader in the definition of dangerousness, and more complicated in the mechanism for discharge.
But narrower in some sense. And see, one of the problems, if what we're going to say is all these people get kicked over into 123, you can be committed under 123 because you're a danger to yourself. You cannot be committed under 123A because you're a danger to yourself.
Correct.
You get more procedural protections under Chapter 123, but in some ways the scope of what can lead you to being committed is broader. 123A, it's got to be a risk of future sexual offenses.
Correct, which is encompassed in the risk of dangerousness to others from Chapter 123.
Correct, but maybe this person could in fact win with good lawyering, could win on the Chapter 123A, but not win on Chapter 123. Are we? The fact that the procedures for him may be better under Chapter 123 is a double-edged sword if you're simultaneously taking on, there's a broader range of bases on which a judge could decide to commit you.
Absolutely. As a matter of fact, if you look at the statistics under 123 and 123A, the reality is the vast majority of petitions for commitment under 123 are allowed.
Yeah.
Whereas, I think in terms of original petition, it's like 60, only 40% of the petitions are allowed under 123.
May I ask you this, and I appreciate both counsel for, I think, trying to help the court deal with what is a sort of internal contradiction in a way. From a counsel's point of view, because I can only imagine what it's like to represent a client with whom you cannot communicate. I mean, as you have repeatedly said, this is my view, and we appreciate that.
I've been doing it for 10 years, so I certainly appreciate it, Your Honor.
From counsel's point of view, with this kind of client, and when I say this kind of client, what I am referring to is a client who has been determined by a judge to be incompetent to proceed to trial under 123A. What is it that is preferential from your point of view, and this may not be the answer to the constitutional question, to having it diverted to 123? In other words, what does 123 achieve that cannot be achieved under 123A? I mean, it may be that from a commitment point of view, this client, your client in this particular case, should have been in a structured environment and so on and so forth.
Is the answer the annual reviews that you get under 123?
No, but you could get
but they're easier under 123.
And actually I was going to suggest part of the answer is, well, under 123A, you get a really, really long period of commitment.
Yeah.
So how many years?
And at the treatment center.
Yeah.
Yeah. How many years how many years of commitment of an incompetent defendant under Chapter 123A does it take to shock the conscience because he does not understand that he has a right to petition to be released?
Well, you start with the premise that it's a day to life, and I think the statistics bear out that the average period of commitment is, I want to say, in the vicinity of 30 years. Might be a little higher or lower.
That's where the guardian would come in, wouldn't they? Wouldn't the guardian, having taken up his interests, say, I forget whether it's every 6 months, every year, it's time now, and then consult with the doctors and so on. I think I can make a case here that he should be released.
But that's the problem, Your Honor. You're dealing with vesting an individual's rights and liberties to an independent third party, probably appointed by the court. I mean, I serve in a capacity as guardian. I mean, I'm a mental health attorney. I've kind of been on all sides of this issue, including guardian ad litem. And it's not, I mean, do you just tell the guardian, does the court issue an order to the guardian ad litem, would like to see you every 12 months, thank you very much?
Well, we do those kinds of things all the time, and sometimes in very serious things involving the right to withdraw life support and all that kind of stuff.
Well, that's in the medical realm, Your Honor.
Mr. Gillis, let me ask you this question differently.
Medical realm, too.
If you are competent under to proceed and you go under 123A, what's the next occasion where you can seek review of your commitment?
It's annually, but the statistics do not bear out that that's how it plays out.
Okay. So annually. So what if there's some requirement that's, and, you know, Justice Cowan pointed to 123 has an automatic annual.
Correct.
What is it if we say that there should be an annual, that the system has to trigger an annual consideration of whether this person is competent to proceed to trial? Well, you're going to say to me, well, he's already proceeded to trial, but you have some kind of where there's some kind of surfacing of this individual, so the individual isn't simply lost, and I think that's what Justice Glaney is pointing to. It's not that the guardian ad litem can decide, well, I don't think this year, or maybe 5 years or 10 years or 20 years, but you have some kind of reporting procedure.
That would be set out in Chapter 123. I think that's one of the main points for diversion.
She's asking.
Let me ask you.
You graft it on as a due process requirement onto 123A, because what you're doing is you're proceeding to trial.
Let me ask you, step back a minute, an analytical question. Assuming that there's a requirement that a guardian ad litem be appointed, what is the difference between subjecting a defendant to an SDP proceeding who's been convicted and he's done his time and he's about to become a free person, nothing standing in the way, nothing holding him? And what's the difference between that and subjecting another person, to an SDP process who hasn't yet been convicted because he's incompetent? I mean, what is the due process difference?
Well,
we've all been assuming it.
See, we are here today dealing with the repercussions of a commitment under Section 15. Now, Section 15 is you're starting with an individual who we know is not competent to participate in his own criminal defense. By implication, he's not going to be competent to participate in the defense of his SDP case.
But we're going to appoint a guardian ad litem, which we are assuming the person will step in the shoes of the defendant and will be able to represent him.
And zealous counsel.
Right.
But see, that's the problem, Your Honors.
But I'm asking you analytically, because you're assuming that there is a due process violation, and I'm asking you, what is the difference, because the person who's done his time is just about to go on the street, and he's being SDP with no criminal process holding him?
There isn't a difference, because in both instances, you're dealing with a prospective deprivation of liberty.
Okay, so there isn't a difference analytically. So then you're conceding that if we require that a guardian ad litem be appointed, there's no due process distinction
between the issue of Section 15
and the non-competent person.
Well, but you're mixing up the competency. The competency issue, the fact that Mr. Nieves was deemed competent to stand trial back in 1998 doesn't bear on the fact that he's not competent now.
No, I'm assuming that he's not competent now.
In both instances, you're dealing with individuals who aren't competent to participate in the judicial process being brought to bear against them, except In Section 15, you have two processes that they're incompetent.
Right, but we're
to
appointing
deal
a guardian ad litem for them. So I'm asking you, what's the difference between, for due process purposes, between the defendant who's done his time and is about to walk out and your client with a guardian ad litem?
There's none, except that the guardian ad litem doesn't know the facts, and that's why I referenced Humphrey versus Cady. The commitment of Raymond Branch, which is out of the Florida Court of Appeals in 2004, and that's why I referenced Del Verde, which was this court's decision back in '86.
Doesn't know the facts of what?
Doesn't know the facts that only the respondent can know, and that's the problem with the guardian ad litem concept.
But that is still also a problem in Chapter 123. I mean, that seems
Correct.
to me that, so, you know, the argument has to come down to your desire to either divert people into Chapter 123 or engraft onto Chapter 123A some of the protections of Chapter 123. Seems to me to be what's at issue. In both contexts, you're dealing with a person facing commitment who cannot cooperate with counsel, a dreadful problem. But let me ask you, I mean, your suggestion that, or the suggestion that there be an automatic, you know, annual review. We certainly have competent people committed to the treatment center, competent people who do not seek an annual review because they know perfectly well that they haven't made any progress in treatment and they don't stand a chance of getting out in 1 year, and they you know, do their treatment programs and make a decision of when they think they've got a better shot. So why should a guardian ad litem have to automatically bring a petition that he or she knows that doesn't have a
I'm not saying
chance?
they should. I think the guardian ad litem
my
concept is ludicrous in this context.
Well, my suggestion was a slightly different one. Not that they should bring a petition, but I was trying to deal with what I thought was your suggestion that, you know, from the state's point of view or from the due process point of view, how did we, quote, monitor a guardian ad litem? Because I was, again, trying to, as I think Justice Cowan was doing, trying to figure out what is the advantage from your point of view representing this man of 123, and what I understood was the annual review, correct?
Yeah, in his right to an annual review of his, or annually petition for discharge under Section 9 of Chapter 123A.
And anything else? I mean, I'm genuinely trying to understand why you're trying to divert into 123.
Because we can't write 123A to look more like 123. 123 exists. The society needs
I
to
think
be
the
able
Chief
to
Justice is
admit
asking
people.
you, if we could write it to look like 123, what is it that you want in what is it that you would write in 123A that's in 123? Isn't that?
Yes.
Yeah. What would you write into 123A?
That the commitments be determinate year to year, that the definition of mental illness be a substantial disorder of thought, mood, perception, or memory which grossly impairs the individual's judgment or actions, and that the dangerousness be one of a substantial risk of physical harm to others due to mental illness.
And what is the nature of the annual 123 reviews?
It's not a review. It's a mandatory requirement on the detaining authority to file for a new order of commitment. And unless and until a new order of commitment is obtained, or unless they file, the individual has to be released.
And it's
So
a jury waiver
want
trial.
you want a different definition of dangerousness, a different definition of mental illness, as well as the sort of burden on the government to seek annual commitment?
What I'm saying is that 123A has a much broader scope
Correct.
than 123 under definition of dangerousness,
Correct.
definition of mental illness. And if you're mentally disordered, the state has to be able to detain you even though you can't defend yourself. But it is not necessary that the state have two means of doing that. One means being very narrowly drawn, and one means being very broadly drawn.
Gotcha.
Thank you,
Thank you.
Mr. Gillis.